call this conference back to order if I could, if people can find a place to sit. So yesterday we heard two, I thought, very interesting sessions that were quite heavy on history, and for this session we're sort of turning more to being heavy on philosophy. There's a kind of standard story, I think, about originalism, which is that in the beginning it was mostly focused on framers' intentions, or, so it was intentionalism, but as it has matured and become more sophisticated, it has moved away from intentionalism to public meaning or textualism or objective meaning or something of that sort. There are still nonetheless very capable defenders of the earlier view, and we are fortunate to have a couple of them with us today. One of them is my colleague Larry Alexander, and as you will hear, Heidi's paper, I think, is largely directed to a kind of sweeping critique of Larry's views. Towards the end, she suggested, I think, that they're not only undesirable but impossible. And Larry's now distributed a little response, which I think suggests that if Heidi's views are right, communication in general is impossible. And I sort of hope that either Heidi's views or Larry's interpretation of the implications of her views are wrong, because otherwise I'm kind of in an awkward position up here right now, I think. But over the next hour and 15 minutes, we'll, I'm sure, get this sorted out, and we have a couple of really eminent representatives of different views here. So I'm just going to turn it over to Heidi and then to Stanley Fish for a response.
Well, great. And everyone should have a copy of this chart that got distributed, and those sitting in the back, there are copies. There's sort of a pile of copies on a couple of chairs back there. So I do have to sort of confess that I'm an intellectual party crasher at this weekend's event. I'm like the Michele Salahi of constitutional originalism. Because while I did actually receive a genuine invitation, my thoroughgoing skepticism about the theoretical viability of originalism makes me sort of an imposter in this crowd. And one of the bases for my skepticism about originalism has to do with my skepticism about the defensibility of intentionalist theories of interpretation, to which many originalists are certainly still wedded. So my particular method of crashing this year's party is to add to my previously published complaints with intentionalism a new set of doubts that were inspired by the provocative new version of intentionalism advanced by my lifelong friends Larry Alexander and Emily Sherwin in their still recent Cambridge Press book, Demystifying Legal Reasoning. And what I want to suggest is that their very thoughtful and sophisticated effort teaches us a great deal about the implausibility of ever succeeding at the task. Theirs is the best it gets. Theirs is a theory that's as smart can be, and my conclusion is that we ought to take it as the best proof available for abandoning intentionalism altogether. So according to Emily and Larry, what justifies lawmaking to begin with, either constitutional or legislative, is that lawmakers can be said to have expertise that enables them to craft rules that represent moral improvements over the status quo ante. And inasmuch as the expertise upon which their authority rests resides within their intentions, judges should set aside the law's plain meaning whenever its application would produce an unintended result. So now we have to ask into the nature of the intentions that Larry and Emily consider dispositive of interpretive questions. And I passed around the chart that I believe comprehensively maps all the possible answers that one might give to such a question, and that thus provides the logical spaces in which Larry and Emily might locate their theory. But rather than walk you through the chart from left to right, what I want to do is chart the answers that Larry and Emily themselves suggest and that I consider in the paper, roughly in the order in which they do so, in an effort to understand where on this chart they end up. So first, it's tempting to think that the meaning of a rulemaker's words should be fixed by the objects to which the rulemaker in fact adverted when employing those words. And this would be to locate oneself in logical space A of the chart over on the right side. It would be to argue that a speaker's own subjectively held paradigm case exemplars fix the extension of his words. So this was Robert Bork's argument when he insisted that the Equal Protection Clause, so limited to its author's exemplars, properly prohibits only racial discrimination. It doesn't prohibit discrimination based on gender, age, religion, and so forth. But intended exemplars are too spare, according to Larry and Emily, as they insist, quote, "We do believe that intended meanings extend well beyond the particular images contained in authors' mental states." So as they say, lawmakers who crafted a prohibition against bears within 1,000 feet of a residential area may only have occurrent thoughts of preventing grizzly attacks. They may never have heard of Malaysian sun bears, let alone thought to extend their rule to such creatures, but still, according to them, it's fully meaningful to say that they meant to do so. So the second thing that Larry and Emily might say that would extend the notion that people's intention, or that would make sense of this notion that people's intentions can extend beyond those exemplars to which they advert, is that people intend to refer to the class of things to which the terms they use extend. And this answer would place them in logical spaces B, C, or D on the chart, still on the right side. So on this interpretation, a lawmaker's use of the term bear would mean anything that's within the set of conventional exemplars of the word bear that on a paradigm case analysis fixes the conventional meaning of the term, that's B, or anything that's captured by the conventional concept of a bear as cashed out in its dictionary definition of the word, that's C, or anything that shares the real nature of bears on a natural kind theory of meaning, and that's D on the chart. But Emily and Larry explicitly reject these related construals because in their view, to say that what speakers mean by their words is whatever their words mean is to substitute utterance meaning for speaker meaning in a manner that abandons intentionalism altogether. So now how can we make sense of their claim that the intended meaning of a text extends beyond the specific exemplars to which its authors adverted, but not to the meaning of the words they used? So now there are times when Larry appears to embrace what might be called the Humpty Dumpty theory of authorial intentions. And this account rests at either E or F on the chart because it assigns to speakers private concepts or privately constructed kinds that fix the meaning of the words they use, extending that meaning beyond their subjectively intended exemplars via private criteria, not via the public criteria that give the words their conventional meaning. So as Larry writes in that letter he just distributed to you, quote, when authorities use terms, they intend criteria for applying those terms. The criteria may or may not be the ordinary criteria the terms suggest, unquote. But there are three reasons to reject this construal of Larry's and Emily's thesis. So first, people can't make words mean anything they mean by them. Language is developed as a means of overcoming the coordination problem that we would otherwise face in seeking to communicate with one another, but it only plays this role because enough people mean by their words what their words in fact mean, so as to make word meaning something quite different from speaker meaning. So recall the exchange between Humpty Dumpty and Alice when Humpty Dumpty says, "There's glory for you," in describing the fact that everyone gets one birthday a year. "I don't know what you mean by glory," Alice says. Humpty Dumpty smiled contemptuously. "Of course you don't till I tell you. I meant, there's a nice knockdown argument for you." "But glory doesn't mean a nice knockdown argument," Alice objected. "When I use the word," Humpty Dumpty said in a rather scornful tone, "it means just what I choose it to mean, neither more nor less." "Well, the question is," said Alice, "whether you can make words mean so many different things." "The question is," said Humpty Dumpty, "which is to be the master?" Well, Larry, like Humpty Dumpty, sometimes seems to suggest that we're the masters of our own meaning. We have private definitions that fix the meaning of our terms, and the task of interpretation is to decipher those private concepts. Now, it's of course true that I can mean anything I want by the words I use, but I can't make my words mean anything I want. And if I seek to communicate with others, I do far better to express my intended meanings with words that mean the same things. Now, I guess it's possible that moral experts could be linguistic idiots. And I guess it's possible that lawmakers are just such idiot savants. And if they are, then I guess there might be a basis for thinking that we should penetrate what their words mean for their idiosyncratic private meanings, just as Humpty Dumpty requires Alice to do if she wants to understand what he means by glory. But now we have to ask two things. First, how could we protect the rule of law values that require clarity and predictability and reliability if we're allowed to fix the meanings of laws by the idiosyncratic private concepts of lawmakers rather than the publicly available conventional meanings of the words they choose? Surely whatever gains in moral expertise we might achieve would be swamped by the costs to liberty and fairness and equality. And second, I think it's generally false that people have private concepts that give the criteria for the extension of their words. When I say bear, I don't have private criteria for the application of that term. I mean to refer to whatever the term means. And while I have a few mental instantiations of the term, and I could list a few properties, those don't fix the scope of my reference. But this would take us back to B, C, and D on the chart, and we know that Larry and Emily reject this return. So the fourth thing that Larry and Emily might mean is that in any given case, lawmakers should be thought to have intended whatever they would have intended if they'd adverted to the case in question. That is, what lies beyond things actually adverted to are things hypothetically adverted to, and those can be included in the class of things intended by the lawmaker. And that's to back way up on the chart so as to include as bona fide authorial intentions, not just actual intentions, but hypothetical intentions as well, and that's G on the chart. But Larry and Emily reject this notion because, as they say, quote, we believe that there are real, not hypothetical intentions about matters not specifically adverted to, and that whether or not a rule that bans bears in residential neighborhoods applies to a species of bear of which the rule makers were unaware is a question of fact. So we can't use counterfactual constructs. So the fifth way that we might make sense of the quest for real intentions about things never adverted to is to look to what lawmakers meant to achieve when passing a law, the goals that make moral sense of their rulemaking to begin with. And to reach for such larger goals is to invoke H on the chart, the further intentions with which speakers intentionally spoke. So in determining whether a panda should count as a bear under the terms of the residential prohibition, we should ask, what larger goal did the lawmaker seek to achieve when banning bears? And if the answer is safety, then as a legal matter, pandas shouldn't count as bears any more than tomatoes count as fruits. But what we know is that Larry and Emily are eager to resist this argument, their claim being, quote, if the meaning of rules is derived from the moral principles that the rules were designed to serve, there are, in effect, no rules and no means for curbing moral error. And so, at the end of this rather breathless but sweeping journey and skipping over the possibility that they might be talking about unconscious intentions that we ought to take into account, I'm returned to the fear that to require judges to search for authorial intentions that reach beyond the things lawmakers adverted to, but don't correspond to private concepts, counterfactual constructs, background moral motivations, unconscious psychological states, or the conventional meanings of the terms used, we're ultimately going to require judges to search for sakes and hunt for snipes.